Well, good morning. Good morning. It's nice to see you all. Welcome to the 13th Annual Executive Branch Review Conference. My name is Nate Kazmarek, and I am Vice President and Director of the Practice Groups for the Federalist Society. On behalf of my colleagues and our practice group leadership, we are very pleased to gather here in Washington, D.C. to discuss the current state of the executive branch. Welcome as well to our audience joining us via the live stream. Thanks for tuning in, and we do look forward to your feedback. A few quick notes and advertisements here at the outset. First, if you are seeking CLE for your attendance today, please be sure to check in and check out using the QR code on the back of your program. Secondly, this year our practice group executive committees have been hard at work to put together a full slate of debate and discussion for this EBR conference. In fact, there is so much to discuss that for the first time ever over the last month, we hosted 4 virtual preview panels covering such topics as the history of executive orders, the weaponization of DOJ, efficiency in civil rights enforcement, and last week we looked at DOJ and environmental regulation. If you missed any of these panels, you can find them in your program by scanning the QR code that's up on the screen there or on page 6 of your program. That QR code will also take you to the live stream recordings of every panel from today. Lastly, I wanted to draw your attention to an upcoming great new mini documentary from our Regulatory Transparency Project. I thought this audience would be interested in particular in this effort. As you know, in March, President Trump issued an executive order scaling back federal DEI initiatives. This new RTP film takes a look at the future of DEI as it revisits the Fearless Fund case, which challenged a race-based grant program under Section 1981 of the Civil Rights Act of 1866. Be on the lookout for promotional emails and the film's release coming up on Friday, May 16th. Turning now to the business at hand, this year's conference theme is Theories of Presidential Power. No doubt, since January, there has been much to discuss each day, often several times a day, about the Trump administration's efforts to remake the modern executive branch and the administrative state. For those of you keeping score at home, here are only a few quick stats reflective of the last 3 months. The president has signed 143 executive orders. For comparison, FDR signed 99 executive orders in his first 100 days, and President Trump signed a total of 220 EOs during the first 4 years of his first term. According to Reuters, as of mid-April, over 260,000 federal employees have been fired, taken early retirement, or have been earmarked for termination. The Trump administration has also fired agency officials and inspectors general. The administration revoked security clearances for lawyers at specific law firms. President Trump, as you all know, tapped Elon Musk to lead the efforts of the Department of Government Efficiency, or DOJ, which has halted government payments and the work of some government agencies. The administration has also inspired over 255 lawsuits, 53 of them coming from the ACLU alone, challenging its actions and sparking a renewed discussion about nationwide injunctions and TROs. Based on these items and more, many have observed that the first 100 days of this administration have been historic. But it's not my job to offer praise or criticism. As you know, the Federalist Society takes no formal positions on legal or policy issues, and we remain committed to convening leading experts to debate and discuss the most important constitutional, legal, and policy considerations of our time. Today, we're very excited about our morning session, looking at presidential personnel, our luncheon roundtable exploring nationwide injunctions, our afternoon sessions looking at presidential policy, and our closing address with the DOJ's Assistant Attorney General for Civil Rights, the Honorable Harmeet Dillon. So let's get started. Our first panel this morning will explore whether we have come to the end of Humphrey's Executor. I am thrilled that Professor Aram Gavor is moderating the discussion. Aram is the Associate Dean for Academic Affairs at the George Washington University Law School. He previously served in various senior positions in the U.S. Department of Justice and the White House, and in private practice before that. He's an accomplished scholar and an in-demand legal commentator. He's well recognized for his expertise in regulation, AI, and national security law. His law degree is from GW, and his undergrad is from the University of Michigan. I've known Aram for a few years, and I consider it my good fortune. His considerable brilliance is only outmatched by his genuine warmth, humor, and kindness. What I'm really trying to say is that he's a Midwesterner from Michigan, just like me. Please join me in welcoming Aram and our first panel.
Thank you, Nate. Can everyone hear me? Thank you, Nate. Thank you to the Society for putting on these important events on incisive and crucial issues of the day. Today's discussion is on Humphrey's Executor, and there's a lot to unpack. We don't have a ton of time, although it seems like 90 minutes is a lot. You really need a couple days to work through all of the materials, so we'll be moving at a pretty quick clip. Very, very lucky to have with us Professor Jed Sugarman, who is a professor of law and the Joseph Lipsitz Scholar at Boston University School of Law. He's a historically detailed-oriented lexical originalist, and he is quite active with regard to separation of powers type issues. He has a book that's forthcoming, A Faithful President, The Founders versus the Originalists. I look forward to its publication, to reading it. And on the question of Humphrey's Executor, which really comes down to, does the president have the discretion to remove a principal officer at will if the statutory basis for that officer's position requires for-cause removal? He has quite distinct views on this. From an April 17th brief to the District of Columbia and Slaughter and Bedoya versus Trump with regard to the removal of 2 FTC commissioners. His position is that Humphrey's Executor is good law, and recent non-controlling opinions suggesting otherwise rely on disproven assumptions and erroneous histories. So we look forward to his unearthing, or his repeating of unearthed constitutional history with regard to this. Next, we also have Alon Werman, who's the Julius E. Davis Professor of Law at the University of Minnesota, also an originalist. So it's really great to see a diversity of views with commonalities and differences. Elon is the author of a number of books that I've read. He has a textbook in administrative law, and he's quite active in the space. He has a differing position. And to really frame up this issue in terms of what's sort of like the biggest thing happening right now, as you know, the president has exercised at-will removal authority for all manner of officers, principal, inferior, and potentially even non-officers as well, without cause throughout the executive branch. Before the Supreme Court, at least as of the 9th of April, so just about a month ago, there was a stay put in place with regard to a case challenging the removal of a National Labor Relations Board member as well as a Merit Systems Protection Board member. And to frame out some of these other cases, as you know, Humphrey's is a 1935 case. Before that, in Myers versus United States, the Supreme Court recognized that Article 2 of the Constitution gives the president an unrestricted power of removing executive officers who had been appointed by him with advice and consent of the Senate. That's Article 2, Section 2, Clause 2, the Appointments Clause. In Humphreys, the Supreme Court created an exception to that rule. The court held that Congress may, quote, forbid the removal except for cause of members of the Federal Trade Commission, and in the court's view, the FTC exercised no power of the executive power vested by the Constitution of the President. And then in recent years, the Supreme Court has clarified that Humphrey's executor's exception to the unrestricted removal power that the President generally has over principal executive officers represents, quote, the outermost constitutional limit of permissible congressional restrictions of the President's removal authority. That's under Selah Law versus Consumer Financial Protection Bureau. Noting a third discussion for today, Jennifer Maskout, who's currently serving as senior counsel to the President, unfortunately had a conflict. She is cited all over that case. So we're really missing her presence on this panel. But in particular, the holding of Humphrey's executor applies only to administrative bodies that do not exercise substantial executive power. You might see that I was looking down as I was saying that because I am quoting from a February 25th letter from the Acting Solicitor General of the United States, then Sarah Harris, to Mike Johnson, Speaker of the House of Representatives, transmitted under a federal statute, 28 U.S. Code Section 530D, that requires a transmittal of information in a letter when the United States Department of Justice no longer intends to defend the constitutionality of a statute. So that's this letter. So there's so much going on. What I'll do now is pause and ask Jed to offer his thoughts for 10 to 12 minutes, Alon to do the same, and then we'll have a really spirited discussion after that. Jed?
Great. Well, thank you, Aram. Thank you for that introduction. I really appreciate it. And let me also thank the Federal Society for continuing to have robust debates about this and being open to different perspectives. To have one flavor of an originalist and another flavor of originalist, that ideological spectrum is amazing. But it actually, but what I will say is, I think one thing that we'll demonstrate here is that there are different approaches to originalism as a method. And what is helpful about originalism is that as a matter of and I'm quoting Scalia in an article by Scalia, a rule of law is a law of rules. And so one reason I'm an originalist is that we can have a debate about the historical basis, and that constrains judges. And so I think that's an important thing, and I hope that, and I do think that there's going to be a test over the next couple of years about just how originalist this court is. And I think originalists and non-originalists have questions about the Roberts Court's actual commitment to the method that they say they're committed to. But also, I really want to thank Elon, because there are a lot of people who are engaged in this debate, and Elon is the most willing to show up and engage and defend, and I think that's commendable. And we have a dog and pony show. I don't know who's the dog and who's the pony, but we just got back from Atlanta, where I workshopped. They gave me the wonderful honor of workshopping the book that Aram mentioned, A Faithful President: The Founders versus the Originalists. And I'm saying that as an originalist because I am trying to save originalism from itself. And I think this is the test case, because the history is clear. The history is clear that the claims made by the unitary executive theory, and I'll describe the three pillars, those three pillars have been debunked. Those questions were raised a long time ago, but there has been work by a cadre, by I'd say maybe 10 or a dozen different legal historians over the past 5 years, in the time since free enterprise, and a lot of the work since Selah Law, that has explained why these three pillars have fallen. But again, I want to thank Elon for having been engaged with all of those debates along the way, and he makes my work better by raising questions, and that's why I keep showing up myself, is that debate improves things. unlike what many people think today in the 21st century, that debate is a problem. So I want to just thank the Federalist Society for being committed to different perspectives. Okay, that's a long windup. But let me say, there's a handout that's gone around. I'm using the handout to use my time more effectively. I'm not going to go through every stage of it, but this also might be a way of seeing the arguments in a little organized and teeing up questions that you might have about some of those details. But let me summarize the three pillars, and I'll try and go through why they have fallen. And I think with Aram's invitation, I'll focus on some of the evidence that is most relevant to the Fed and Humphrey's executor. So the three pillars are the executive vesting clause of the first sentence of Article 2 of the Constitution, which I have here on the handout. The executive power shall be vested in a president of the United States of America. And the second pillar is the take care clause, that the president shall take care that the laws be faithfully executed. I like to call that the faithful execution clause, except there are two, because the president takes an oath to faithfully execute the office. I'll say more about the importance, the legal importance. This is not just a nod to God. I mean, I love to nod to God, but that's not what the faithful execution clause is actually about. It was about it had a legal constraint as opposed to a legal empowerment, meaning from the Magna Carta through the 18th century, through the patriots who took the oath as a legal matter to be able to distinguish their fealty, their allegiance to the emerging states that had rebelled against England. It was a defense against treason prosecutions. It had legal significance. That's pillar number 2. And pillar number 3 is the ostensible decision of 1789 by the First Congress, where there actually is a lot of evidence in favor of Humphrey's executor and the Fed. But let me go through briefly about the main evidence against those pillars, and then I will highlight a couple of claims about Humphrey's executor and let's say more treasury or fiscal matters, which is what the dividing line might be for the Roberts Court, even if they're not persuaded by all this other evidence. So first, executive vesting. What it was executive power, there are a series of articles, but the most recent article I published on this came out in the Notre Dame Law Review in November called Venality, the strangely practical history of unremovable officers and limited executive power. It turns out there's a book that's often quoted by Hartley, L.P. Hartley, The Go-Betweens. The past is a foreign country. Turns out England is literally a foreign country. And England, the monarchy of England was a different system. But the Americans did pick up on and inherited some background understandings. The king could not remove many officers, now not all, but many officers in England, because they had offices as property, and that that system declined and was reformed, but it was still in place by the founding. So the founders were well aware that many offices were held as unremovable property. And when you go back into Marbury versus Madison, there's a puzzle that many people just didn't understand and couldn't unpack. And the work over the last, so why is it that Chief Justice John Marshall says 3 separate times in Marbury? I mean, people have heard of Marbury? I just want to be So Marbury is one of the 3 most famous con law cases, I'd say. Right, and yet this puzzle persisted until the excellent work of Jane Manners and Lev Menand, and I piggybacked on them, to show that the default rule was totally different in the 18th century. If a statute was silent, if a statute gave an officer a tenure of limited years, like 5 years, 6 years, the default rule was that it was unremovable, that the term was 5 years, and there was a lot of good reason. I explain in Venality for this. So Chief Justice John Marshall basically tells us that whether or not you attach this as a property rule, it was an anti-removability default rule. So there's more to say about that, but the main point here is that as a matter of 18th century original public meaning, the term executive power did not imply removal. Okay, that's point number 1. On the pillar number 2 of the take care clause, a faithful execution. Faithful execution had a meaning from the Magna Carta up through the 18th century that it was a legal limit often justiciable in many ways, that an officer had to defer to statutes. And the oath, the framers knew knew the coronation oath. They didn't use the language, anything close to the coronation oath. They chose language from mid-level or high-level officers to impose a duty of deference to legislation. Deference to legislation, i.e. legislative primacy, and faithful execution was their language for that. Now, I'll just trust the living constitutionalist liberal justice of the 1980s, Chief Justice William Rehnquist on this. This is Rehnquist. Rehnquist says I'm paraphrasing Morrison versus Olson, which, by the way, unlike I think what some people think, Scalia was a dissenter. That wasn't the majority opinion. He was a lone dissenter. Rehnquist says that there's nothing inconsistent between showing good cause and being able to faithfully execute the office. Good faith and good cause are cousins, very closely related cousins. I don't know that they could get married in all states, but they're very close cousins. So the point is that there is, all the way back to the founding, this is not just a matter of congressional invention. The idea that the president's powers, especially only implied powers, if implied, are still governed by the text of the Constitution. And that good faith or good cause, can Congress elaborate on that question? I think it can. Okay, third, the first Congress. So I'm going to just, if you have the handout in front of you, I'm not going to go into all the detail. All that detail is an article that ballooned out to 115 pages. Thank you, and I'm sorry to the editors at the University of Pennsylvania Law Review. But it turns out that the decision of 1789 is a myth. Only 9 members of the House out of 9 out of 54. So if you're keeping score at home, that's 17%. Only 17% articulate a presidentialist theory. Now, there are a number of others, but a lot of this debate that came out of the House is incredibly complicated, and I think it even begs the question, why are we turning to the first Congress as originalists? Why is it that the first Congress gets so much weight? Well, it's out of necessity. Not proper, but it's necessary and not proper. Why is it necessary and not proper to rely on the first Congress? It's because the ratification debates, the most important material for originalists, as what we the people ratified in 1787 and 1788, the historical evidence is overwhelmingly on the side against the unitary executive theory. Madison and Hamilton in the Federalist Papers side with, and that's more relevant to what we the people debated, not the first Congress. But there's also only one moment that anyone has been able to point to in the ratification debates where anyone pointed to an idea of removal, and it was associated not with executive power, it was associated implicitly by the citation of the Commander-in-Chief Clause. Because the only removal cited in the ratification debates was over Army officers, Navy officers, and the militia. That is a pretty big expressio unius problem. If the only time the ratification debates mention removal, and they didn't mention executive power or take care, but they only mention military officers under the Commander-in-Chief Clause, that tells you that not even the biggest critics of presidential power thought it was plausible that the executive power clause implied removal. So let me wrap up with 2 other points of originalism about FTC and Humphrey's Executor. One is the sinking fund, and this is work that was first by Jerry Mashaw, but recently by Christine Chabot in much more detail. Hamilton proposes a sinking fund with 5 members on it. That sinking fund was about debt sinking. It was to resolve the debts. This was, by the way, if for musical fans, this is rap battle number 1 from Hamilton. Hamilton proposes a sinking fund, and that sinking fund has 5 officers: the Attorney General, the Secretary of State, Secretary of Treasury, and the Vice President, who is unremovable, and the Chief Justice, who's unremovable. Okay, and that gets enacted, and that has tremendous power. And if we're talking about liquidation, we're talking about liquidating debt. This is also liquidating whatever that means about the Constitution. Sinking fund is pretty clear original evidence that something like the Fed. But here's one more example, and it's Madison's proposed comptroller. Now, this is going to get into the weeds. And Elon is going to quote one line from the proposal, but if you read all of the other paragraphs after the proposal, it is unmistakably clear that everyone debating Madison on his proposed comptroller thought that what he was proposing was a comptroller that could be removed only for good behavior. Let me repeat that. Everyone debating Madison said, Madison, you've just proposed a comptroller serving at good behavior. And that was Madison's approach to independence, and ultimately it didn't succeed. But the point is, this was highly contested, and this proposal came soon after what was ostensibly a decision of 1789. Madison distinguished, but let's just say, if you're not persuaded by me that the decision of 1789 did not decide anything, right? I think what Elon and I might agree on is that what it related to was department heads. A week after that debate, Madison comes back and says, well, here's comptrollers. Comptrollers do something like, and I'm using modern terms, but it's a way to understand what Madison was trying to propose here. Comptrollers do quasi-adjudication. Comptrollers have to decide fiscal cases when there are contested questions, legal questions, between citizens and the government. And he said that's like an inherent conflict of interest. We need an ALJ here. Okay, he didn't say ALJ. But we need a quasi-adjudicator under the executive branch, and that adjudicator needs to be independent, and everyone understood him to be proposing a comptroller serving at good behavior. Good behavior is much more protected than the FTC or the Fed. So if you thought that Madison and Hamilton were on your side, right? Well, if you thought Madison and Hamilton were on the unitary executive side, we see again and again that from original public meaning that these issues were resolved in ways that previewed, even if they didn't use the language of quasi-legislative or quasi-judicial, in our modern terms, there was an emphasis of what is quasi-legislative? It's like specific expertise below the level of Congress. That was part of those debates, expertise in fiscal matters. And second, quasi-judicial, that goes all the way back to the founding as the importance of independence for those who adjudicate cases. And I'll stop there.
Thank you so much, Jed. Very interesting. Summing it up, Humphrey's Executor is good law. New evidence since Humphrey's Executor demonstrates that Article 2 did not imply unconditional presidential removal authority. The gauntlet has been thrown, Alon. Your response.
So thank you for having me here. Is this working okay? Can you hear me?
Yes.
First of all, I'd just like to thank Jed as well. Jed has made my work better, and he really forces me to grapple with things that I didn't think deeply enough about. He's convinced me that the decision of 1789 has more ambiguity than I previously appreciated, and I do think we make each other better, and so I'm very much glad we're here. Having said that, I wish I had gone first, because I'm not going to respond to everything he said now. Hopefully there'll be another round. I'm going to stick with what I sort of wanted to say, the affirmative case. But let me just say he's wrong about the comptroller. He's wrong about the sinking fund. He's not wrong about Marbury, but Marshall was wrong about Marbury. Just like Marshall was wrong about everything else in that opinion, actually, except the bottom line of judicial review follows from the nature of a written constitution. But of course you have to deliver a commission for it to be effective. Okay, so Marshall was wrong about a lot of things in that case, but we can come back to it. I also think you're wrong about Madison in the Federalist and Hamilton in Federalist 77. That's what I'm not going to talk about in this round.
I took notes. Yeah.
As to the comptroller, though, okay, let me just, and then I promise, this doesn't count against my time, does it? Or it is? Okay, because I haven't looked yet. Okay, it's like, the line in the comptroller debate, which, by the way, Madison withdrew the proposal after he got attacked for it, right? The line that he said I'm going to rely on was Madison's actual proposal, which was to create a short term of years for the comptroller unless sooner removed by the president. That was the proposal, right? And I would be eager to understand why that isn't decisive of this question. What Madison, I know I said I wasn't going to do it, I'm going to do the comptroller. What Madison was saying is he wanted to create independence in this officer by creating a short term of years. Why is that relevant? Because as soon as the term expired, the comptroller would need approval by the Senate for a reappointment to the office. And so you couldn't just be a lackey of the president, because you'd have to respond to the Senate if you wanted that reappointment. But still, you know, the language said unless sooner removed by the president. And Madison's proposal confused a bunch of people, right? I don't remember if it was Benson or someone said, what are you talking about? The comptroller isn't going to be independent. He's going to be the most accountable person in the whole department, in the whole executive branch if he has
said
to.
he'd have accounts as a comptroller. That's it. That's a joke that clearly didn't fall.
I'm not even following it. I'm pretty, anyway.
Checks and balances and accounts.
Okay, well, this definitely does not count against my time. Okay, so now it's not.
And don't count it against me either. All right.
Okay,
Yeah.
9:30. This is what I was going to say. Okay.
This is a friendly fight, so.
Yeah, it's true. It could be much worse. Okay, so Humphrey's Executor, just high-level background, like everybody agrees that its reasoning is dead. Okay? There's no such thing as quasi-legislative, quasi-judicial power. There are 9 votes on the Supreme Court against that proposition. If you look at SELA law, what was the dissent focused on? Morrison v. Olson. They weren't focused on this idea of quasi-legislative, quasi-judicial power. The reasoning is dead. I think Jed might have just tried to resurrect it a little bit, but basically there are 9 votes on the Supreme Court. If it's not legislative power, if it's not judicial power, then it's executive power. The question is, okay, so what is the actual answer to this question of for-cause removal under the original meaning of the executive power clause, the take care clause, the necessary and proper clause? And then, the court had never told us, because in Humphrey's Executor, they made up this new category of stuff, of power. Okay, so what's the answer? So I was doing this morning in the hotel room. There are at least 7 possible conceptions, I'm gonna be very quick, about what kind of power over law execution the executive vesting clause grants, okay, very quickly. And then I'm gonna tell you what I think the right answer is, and I'm gonna sound, like I'm being liberal or progressive or something, but just wait till the end, okay. Option 1 is it grants nothing, right? It's just identifies who the president is going to be, and the president's only power over law execution is what can be inferred from the take care clause. Okay, that's one view. View number 2 is it grants the president has the power to personally execute all laws. This is not the conventional view. I think it's Cyprokash's view. I don't think many formalists have that view, but that is a possibility. The most conventional formalist view is the president can direct, control, and remove officers. You can't personally execute the law, but he can direct, control, and remove them. A slight finessing on this is, I think, Judge Naomi Rao's view, which is that, yes, in theory, the president has a right to control, but the only way to enforce that is through removal. In other words, an officer could disagree with the president or disobey an order. It wouldn't make that action ultra-virus. The officer's action would still be lawful, but then the president could remove them for failing to obey the instruction. So it's a fine distinction. Gary Lawson's view is the president doesn't have the right to remove as long as he can countermand anything. Right, and so the acts of officers would be ultra-virus if they ignored the president, and you can show that, but the president doesn't have to be able to remove them. John Harrison's view, this is view number 6, is that the president either has to be able to remove or control, I don't care which, just one way or the other, it's how you retain the executive power. 7th and last view is my view, which I'm going to briefly sort of defend, which is I think the president has a constitutional right to remove the officer, but not necessarily a constitutional right to control the exercise of that officer's discretion. And what do I mean by that? Anybody could bark orders. Anybody could command an officer to do something. The question is different. The question is the constitutional obligation on the part of the officer to obey. And in this respect, the Constitution actually only says one thing with respect to principal officers, that they have to give the president information about their duties. In my view, so that the president can intelligently exercise the removal power. This may seem like splitting hairs, but it actually distributes political costs in a pretty sensible way. If the president wants to interfere with an officer's exercise of their duties that Congress has given that officer, then the president has to be willing to fire the officer, which comes at a high political cost. And the cost is going to be higher if you think the interference is illegitimate or there isn't this constitutional right of control. It's basically Daniel Webster's response to Andrew Jackson firing 2 secretaries of Treasury because he wanted them to remove the US Treasury deposits from the Bank of the United States, and that they didn't do it, and he got censured in the Senate. So the political costs are actually distributed in an interesting way if you care about both accountability and some degree of expertise and independence. Okay. That was only 4 minutes, okay.
Minus my bad jokes.
Yeah, that's right. In 3 minutes, let me start with the proposition of the removal power.
Why you can go like for another 5, it's 10 to 12 minutes, you're good.
Good, starting now. Okay,
sure.
So three.
Formalists are precisionists, so that's where we are, yeah.
Well, I'm cherry picking the evidence of the rules, as Jed would say, maybe. Okay, so let me start with removal, then control, and then let me talk about what the implications are for for-cause restriction. Where does the removal power come from? This is really interesting. In Michael McConnell's book, he says on the executive power, the presidency, the president who would not be king, he says it's a great mystery that the Constitutional Convention doesn't talk about the removal power. Jed just said it's a mystery that the ratification debates didn't talk about it. Okay? But there's an explanation that Jed has actually made me appreciate more in his own work, right? In a part of his work he didn't mention today, which I think is useful. He takes different things from it and he can respond to what I'm about to say. But here's what I take from it. Okay, the executive power was understood as the power to oversee the execution of the laws. One person unaided could not possibly do that on his own. So what's the conclusion? The appointment of officers to assist was understood to be a quintessential element of the executive power itself. The executive power, the power to oversee law execution, necessarily entailed a power to appoint officers to assist. What does that have to do with removal? There was a common law maxim that said, he who appoints removes. The removal power is incident to the appointment power, which makes sense because if you have the appointment power, then you just appoint somebody new and then you displace the prior officer, right? That is how commissions actually worked. You know, you are commissioned to this new office and the previous office holder is hereby displaced. So why was the removal power not talked about? Because until the Beardley Committee, the Committee of Postponed Matters, which was in September, I think, so like at the very end of the Constitutional Convention, the removal power, the appointment power, excuse me, was not shared. It was divided. The Senate had the appointment of ambassadors and judges, and the president had the appointment of all other officers. So you don't need to talk about the removal power, because the president would remove by making new appointments of his officers, and the Senate would remove by appointing new ambassadors. It wasn't until the Beardley Committee gave all of this power to the president and Senate together, right, nomination and then buy-in with advice and consent, that it raised this question. Well, wait a minute, does this mean the president and Senate together now have to remove, according to the common law maxim? This is why they debated this in 1789, because they didn't have an opportunity to think about it until they were creating the departments. It just wasn't an issue until it was too late to have thought about it, right, in the Constitutional Convention. So this common law rule might suggest that the president and Senate together must remove, right, because they together appoint. And a lot of people took that position in 1789, and Madison said, that is totally plausible to me. And I would think it's correct if the Constitution had said nothing else on the matter. And he thought that the take care clause and the executive power clause, but again, that's a bit question begging here, derogated from the common law rule. He basically said the president will be unable to ensure faithful execution of the law if the Senate gets a back-end check on his removal of officers. Then it's effectively, and I'm sort of speaking for Madison here in my own language, it's effectively transferring the take care duty to the Senate. But otherwise, he would agree. So when you look in 1789, and actually Jed's pie chart is super helpful if you have it, okay? A majority of members of Congress thought that the Constitution answered this question. Either the president and Senate together have this power, or the president alone has this power. It was only a small number who thought Congress had discretion whether to give the removal power to the Senate or not, which is very interesting since that's the conventional academic view today. And it's like, where did that come from exactly? So removal, yes, but let me suggest that that doesn't necessarily answer the question of whether Congress can impose for-cause restrictions, because the president has the removal power in that case, but it's conditioned. Well, I want to suggest that it's a bit more complicated and that the secret star of this might be the necessary and proper clause. Under my view, the opinions clause actually provides the only constitutional obligation on the part of officers to obey. Otherwise, why would you need the opinions clause if the president, by virtue of the executive power, could direct and control and the officers had to obey the president? You wouldn't need the opinions clause there. Washington, Jefferson, Madison, with respect to the comptroller, said to multiple supplicants, I cannot interfere with the comptroller's duties. I can only remove in the case of malpractices. So this is pretty consistent with prior practice. And I've called this the other decision of 1789 in the same statute, clarifying, in my view, that the heads of department, that the president can remove the heads of the department. Here's Foreign Affairs and War. There's this interesting clause that said, the said principal officer shall conduct the business of the said department in such manner as the President of the United States shall from time to time order or instruct. Super interesting. If the president already had this power, why would Congress need to have established it in the statute? Okay, what's the implication for cause? Just give me like another 2 minutes. It's one possibility is you could say, look, this was the dividing line between principal officers. The president could remove. That was the president's power. He couldn't direct and control, and it's up to him to decide whether they are faithfully executing the law. I think this creates on its own a problem for for-cause restrictions, at least if they're judicially reviewable. If they're judicially reviewable, whether there was cause, then it's no better than giving the Senate a check on the removals. Now you're transferring the take-care duty to the courts, and that's problematic. But let me suggest something else. Under the necessary and proper clause, which I'm not going to get into how it operates, would it be necessary and proper under our form of government to create property rights in holding federal office? The venality that Jed described in his talk. James I made Francis Bacon Attorney General for life. Could Congress say that the president may appoint an Attorney General for life, not to be removable, but for cause, it's effectively granting a lifetime tenure? I think Jed's answer is no to that, interestingly. I think we agree about that. Yeah. Well, if that's true, then what about 99 years? Oh, that's cutting a little close to life for most people. What about 15 years? What about 7 years? What's the difference? You're creating a property interest in holding federal office, which seems fundamentally incompatible with Republican government. Jed, now, so I'm going to needle him a bit, and maybe he can respond to this, relies on Montesquieu in his work, where he says that removal is an element of despotic government, because you need to be able to remove offices quickly. That's true. In a monarchy, Montesquieu says, the buying and selling of offices is okay. People have a stake in the system in that way. But Montesquieu in that same passage says, but of course, property rights in office, the buying and selling of offices, would be inconsistent in a republic. And he quotes Plato on this, saying, creating property interests in federal office would kind of like making a man a pilot or a sailor for his silver. What's the connection to being able to pilot or a ship? And so I would suggest that under the necessary and proper clause, Congress probably doesn't have the power to create property interests in offices. And what are for-cause protections but such property interests? Okay, hopefully that's enough for Jed to start getting angry at me.
No. All right, so just to sum up, Lon's position is that Humphrey's is bad law, and that the president has very bad law, and also Marbury might have been bad law. Or might be still good law, but for bad reasons. We didn't quite get into that. And that under the relevant provisions, the necessary and proper, the executive vesting clause, the opinions clause, the appointments clause, the take care clause, his position is reinforced. I have a lot of questions, but I think much more important is I want to give Jed an opportunity to respond, and then Elon to respond to Jed. And this isn't like round one, this is like round 6, like over multiple days and weeks and years.
So this is tremendously helpful, and I actually want to go in reverse order of your arguments, because I just want to emphasize that there's what we agree about, and I think what we agree about is the significance of the necessary and proper clause, and this is really breaking away from maybe some of my political priors, but in this work, as I and others have worked on, and I'm really relying on a school of thought that Gary Lawson and Guy Seidman have, and Robert Nadelson have most pioneered about fiduciary constitutionalism. So the title of my book is a textual reference to faithful execution, but there are many parts of the Constitution that highlight a fiduciary background to the Constitution. Now, Gary Lawson and Guy Seidman go in one direction. I think their book is worth reading. I disagree with their I'm more sympathetic to the non-delegation argument that non-delegation exists, but for other reasons. However, there is the fiduciary concept of necessary and proper is a more robust version that John Marshall himself, because he's right about everything, right? John Marshall in McCullough versus Maryland applies necessary and proper to figure out if the national bank is constitutional. And at that threshold of necessary and proper, I mean, it's loose, it's informal, or it's a standard more than a rule, but you still have to demonstrate, Congress has to demonstrate that what it's enacted under the sweeping clause, it's not as sweeping as it actually originally meant. It has to be necessary and proper, okay? So one thing I think we agree on, and one argument for the Fed being treated differently, or one reason why the Humphrey's Executor is still good law, is that this is not plenary power for Congress. Let me repeat that, right? And this is where I maybe disagree with others on the left. There is no plenary grant of unenumerated implied powers in Article 1.
We should end right now. Just like this, that's your CLE.
And this is, I mean, this is heresy in many ways, as Elon knows, to defend enumerated power doctrine and non-delegation. But the upshot is it's also a way to distinguish between the Fed and other offices, because I'd say a lot of the worry that on the left, right, and center about the unitary executive theory is wiping out the Fed. And I think one argument, and you're right to worry about that, or especially if you're looking at your 401k, right? An argument for the Fed having a particular design, I'd say it extends to other kinds of commissions, is tailoring it to what's necessary and proper. So, okay, so I want to highlight, I think we agree about that, and it turns out that's not just me talking, and that's not just Chief Justice John Marshall, but also members of the First Congress articulated something like that as a reason why congressional recognizing a power to create independence was not a plenary power to, for example, when Elon asks me, well, not an attorney general for life, or how about 99 years? I'd say, on a question of necessary and proper, we can have that debate about what's necessary and proper for the attorney general. We may disagree about the exact independence, but that's why the necessary and proper clause is why it goes well beyond Congress's power to create any life tenure in executive offices. Okay. I'm going to skip to two textual points that I think are hugely important here, and they cut against Elon. One is this appointments clause argument. Okay, it turns out that the compromise that Elon highlights is actually it gives up the ghost on the argument, because when they went to this committee of postponed powers, they did not leave appointment power to the president alone. And when they shifted it, like look at Article 2, the president has the power to appoint with the advice and consent of the Senate. And Elon, you're acknowledging that they couldn't rest on the sole appointment power of the president. They knew what they were doing. And so first, that is the way the maxim works. You go out the way you came in. Removal follows appointment. That was the common law maxim. So then that's an argument for the Senate. Now, what Elon doesn't tell you is that the only people who made this argument and cited the common law argument were the senatorials. No one in the first Congress believed what Elon just told you. And I think that's a problem for what Madison tells you, because Madison cites it. No, listen, Elon, you just told, if you go back, review the tape. What Elon told you is, Madison says, this common law maxim would be a problem. Why does he say it would be a problem? He says it would be a problem because we have the president and the Senate jointly appoint, and that's what the maxim means. But there's an exception. But he says later, he says the reason why that maxim doesn't apply is another textual argument. But those are two different arguments, Elon. Madison agrees that the only way the maxim applies is president plus Senate. Now, I agree with Elon that the only people who made this argument are the senatorials, and the senatorials lost. But here's the point of the pie chart. Okay, the point of the pie chart is that there are lots of if nothing else comes away from the pie chart, you should see that lots of people should be upset because they're getting small pieces of the pie. No one wins the decision of 1789. That's why the article is called The Indecisions of 1789. When you have, so this is, I can say much more about this in some other venue, but when original public meaning is unclear, then it's not fixed. When they couldn't agree, and they couldn't agree in the convention, they couldn't agree in the first Congress, it means that we have to then rely on other textual sources, and that's the necessary proper clause. Finally, on the handout, Elon puts a lot of stock in the opinions clause. And it turns out the opinions clause is the most overlooked part of this whole debate. The opinions clause in the middle of the handout, under section 2, the president may require the opinion in writing of the principal officer in each of the executive departments upon any subject relating to the duties of their respective offices. Why would the founders, why would the convention delegates include that sentence if the president had a power to remove? And members in ratification and in the first Congress, people cited that clause and said that tells you that the president doesn't have removal or control because it implies that they had to state it. Now, I'm not going to go into all of the detail, all of the different theories, but let me just say, there is an academic consensus that this is a problem for presidential power, that this clause gets included. I have dug into the background of the information or opinions clauses that preceded 1787. All 4 times state constitutions used anything like an information or opinion clause, it was because it was between 2 independent bodies, a council of revision, judges. The reason why those clauses were added to state constitutions was to say, between these 2 independent bodies, how can we clarify that one body has a power to ask questions of the other when they're independent? That's the context. The original public meaning of the opinions clause is is perhaps the best textual evidence against the removal argument of the unitary executive theory.
Thank you, Jed. Alon?
Let's just keep going. Okay, I think I'll focus on 2 things here. One is the opinions clause. Under Jed's view, and I think it's the prevailing academic view, right? What power does the president have to do with the information in question? Why does the president need the information if he can't direct them, if he can't remove them? What's the president to do with it? So Peter Strauss has an answer, which is like, oh, well, the president is effectively the persuader in chief. Okay. He could cajole, coax, mobilize different aspects of the government, but at the end of the day, he's just the persuader in chief, right? And that just seems totally inconsistent with the way the administration actually worked and the opinions clause actually operated, whereas under my view, the opinions clause, I do think is a problem for the direction and control view of the executive power, but it makes perfect sense under my account, which is if the president's only power is to remove, you're gonna need some way to get information before exercising the removal power. People say, oh, well, you know, he could have always commanded and threatened removal. It's like, but yes, but you want the president to have information first before he removes, which is why this is the one constitutional obligation on the part of principal officers. Now, Jed, I'll let him, speak to it. Yesterday, he was asked this by Gary Lawson, actually, in his book workshop, and he had an answer. It's, well, the president can get information and then relay it to the Senate, and the president and the Senate together. So he'll have an answer to that. But under the prevailing sort of persuader-in-chief view, that just seems so inconsistent with the way executive power operated for the first century and a half of the founding. Let me say something about the Fed, and then maybe I'll stop. The example of the Fed, if I may say so myself, illustrates what I view as the brilliance of the proposal that I have advanced today, which is the distribution of political costs, under my view, of the president doesn't necessarily have a right to control, that Congress can vest discretionary duties in officers, and it is those officers' obligation and power to execute those duties, okay? But the president nevertheless has oversight through the power to remove. And therefore, if the Congress wants the Fed to have a degree of independence, it would be improper to remove the Fed chair for purposes of interfering with the Fed's duties. But the president nevertheless has that power, and if he's willing to take the political cost, absorb the political cost of doing it, then he can go ahead and do it. And this is, I think, a brilliant distribution of political costs. Why? What does it mean the Fed's independent? Nobody's independent. Give me a break. That's not a thing, okay? You want them to exercise what they mean is independent from the president. They're not independent of passion. They're not independent of partisanship. They're not independent of political parties, okay? So if you want to create some degree of expertise and independence in officers while ensuring a degree of accountability to the people through elections, what better way than this distribution of the president can remove, has no constitutional right to control or direct, but he can attempt to do so through the removal power if he's willing to absorb the political costs. And I think that's a perfectly sensible way to run the Fed and the system in general.
So this is great. What I'm going to do now is sort of take moderator's prerogative. The die has been cast, opinions have been displayed, and there's some commonality, but as to the question of Humphrey's, there's a strict divergence. I want to unpack some of this and react to some of these points. The first is I want to introduce the thought experiment using a presidential action from January 20th of this year. And this is really for Alon, but also I'm interested for Jed. So, option 7 is the president has the right to remove, but not the right to control or command. So on the first day of the term, there's a statute. It's the TikTok statute. It's the Protecting Americans from Foreign Adversary Controlled Applications Act, known as PFACA. We don't need to know too much about PFACA, but what I do want to focus on is Section 2 of that action. I hereby order the Attorney General not to take any action on behalf of the United States to enforce a federal statute that authorizes the Attorney General to enforce. Another subpart, the Attorney General shall take appropriate actions to issue written guidance to implement my order to the Attorney General. And then third, I further order the Attorney General to issue a letter to each provider of apps stating that there has been no violation of the statute and no liability for any conduct that occurred during the above specified, at least at this time, 75-day period. So when I read that, that struck me as different from prior presidential administrations, including Trump 45. So this goes to sort of like the precedent aspect of option 7. Is that hypothetically, a lawful order?
So I don't know if the question is the president ordered the Attorney General to do something unlawful,
You're not owning this.
right?
Yeah.
I don't think that's a lawful order, right? If the question is, does the president have the constitutional power to direct the Attorney General? Under my view, it would depend on whether the statute gave that power. We could also understand a default rule where if it's not, independent, like the Kagan presidential administration, that if it's within the EOP kind of branch, then the presumption is the president can direct and control. I'm fine with all of that. That doesn't mean that the president can order something unlawful, which I don't know if is that what you were getting at, but like little.
Can the president, so the president, at least within the statute, authorizes the president to delay the effect, of the PFACA if he makes certain findings. Okay. Which, in some respects he did, but then he is then going further than that express authority to direct the Attorney General to engage in or not engage in certain law enforcement actions. Here, the forbearing of enforcement and also the affirmative obligation to essentially create a safe harbor by the transmittal of a letter providing his opinion on the law.
So,
where are we with that?
So let me compare that to the situation of Andrew Jackson and the bank deposits. Why was that so controversial? Because the law said that the U.S. Treasury deposits shall remain in the Bank of the United States unless the Treasury Secretary, the Secretary of the Treasury, shall form an opinion, and that in his judgment they are not safe deposited in the Bank of the United States. The duties, the discretion, the obligation was imposed on the officer because Congress thought that that was the best place for that discretion to be exercised neutral, a political, expert way, whatever you want to call it. And the problem there was that Andrew Jackson, but even Andrew Jackson, by the way, to be clear, was very careful. There are notes from his cabinet meeting in which they're discussing this. And he tells the Treasury Secretary, he's talking to the audience, to his whole cabinet, and he says, I don't want to be mistaken for directing the Treasury Secretary in what to do. However, it would please me if there was a uniformity in administration of my policies, right? Basically strongly suggesting I will remove you because at least I have that power, even if I cannot directly control. And the reason it was controversial was because everybody knew that the removal was done because the president was trying to supplant the judgment of the Treasury Secretary for his own judgment. In this case, the Attorney General, the funny thing is there might be like a norm that the Attorney General should be independent, but it's actually quite unlike the bank deposit case where I don't think anybody actually doubts that the president has the statutory authority to direct the officer and certainly could remove the Attorney General if she ignored him. So again, it would depend on exactly how the statute is written and in whose judgment it is, right, to make that determination.
Yeah, absolutely. And the reason why I asked, I framed that hypo is that the precedent requirement for your option 7 is like a really significant one, right? Yeah. So just to reveal that, Jed, what are your thoughts?
Yeah, let me take this. I think it's an excellent question. This also, I think, frames, I'm going to take this up to a higher level of abstraction about the questions. Yeah. I think one answer is around, I think maybe Congress's statutes relate to answering that question, which is that when Congress decides to create the Department of Justice. I have an article on this. It's actually very different, right? So again, go read that article about the founding of the creation of the DOJ was much more independent than it is today. And as time has unfolded, those other changes reflect a congressional decision, a congressional choice to make the DOJ an executive department under the president. And I think that statutory background is, I think, the best answer to the question, which is it's because Congress has made the Attorney General under the unitary executive control of the president. But that's different from the question of whether Congress could change that. Congress made different choices, like the Tenure of Office Act that protected officers, requiring Senate agreement to remove in 1867. Could we, looking forward, and I make this argument here, moving forward, we have seen problems by presidents from both parties of misusing the Department of Justice and misusing prosecution. I also think we've seen state prosecutors, like the Manhattan DA, abuse prosecutorial power as well. So I would make an argument that moving forward, the reforms we need to think about are how to make the administration of justice more independent. And I think, as a matter of the necessary and proper clause, that would be one way to address this problem.
Yeah, so that makes a lot of sense. I think it's well argued. Of course, what I really like about your respective responses, first one is you reference Andrew Jackson. That makes a lot of sense because in 45, like his portrait was in the Oval, right? And the question then is has in the first 100 days, as Nate described, and one of the implied questions is Trump version 2.0 moving in a departmentalist direction? And then Jed, your response, of course, it's grounded in a lot of good reasons, but then we have to counterbalance that against the pardon and the commutation power. And like the purest version of the take care clause authority would have, at least in my mind, would be like criminal prosecution, right? For which there's all kinds of other constitutional checks. Another question that I want to frame, again, a premise question with regard to Humphreys, and this, you brought this up at least with regard to constitutional history unearthed since 1935. What about the statutory changes to the Trade Commission? It's a very different Trade Commission than it was in 1935. What do you both make of that? The Trade Commission has much more authority, sort of had a zenith until the early 70s before the Trade Commission Improvement Act, because the Trade Commission was regulating toothpaste and soda, and essentially got all of American industry against it. How does that play into this?
So to take the first crack at this, I'll make a concession against interest here. So I had a conversation a year ago with Eli Nachmani, who's a young scholar. He may even be here. Eli.
Eli's a good guy.
I was gonna. If he was here, I would totally change what I was gonna say. No, he talked. I haven't read the article, but I had a conversation with him, and I think there's another scholar that's made a similar point. That the FTC, that the 21st century FTC is not the FTC that was upheld in Humphreys, and I think that's the best argument about why you could why you could actually leave Humphreys in Humphreys as a valid precedent or update it, but also strike down the FTC's independence, is that the FTC has become a lot more executive power-ish than quasi-judicial and quasi-legislative than it by its design in 1913. And so I think I think it's important to recognize that those details matter. I think they matter as a matter of the necessary and proper clause, and also paying attention to Congress's range of choices. But I'll stop there.
My answer is simple and will shore up my Federalist Society bona fides, which I may have given up a little bit throughout today's discussion, which is it's executive power, and it's always been executive power. If it's not legislative power, if it's not judicial power, it's executive power. And what it was doing in 1935 was executive power. And if it wasn't, then they should have been doing it anyway, because they're not Congress and they're not a court. And so this whole idea of substantial executive power or insubstantial executive power, there's nothing in the Constitution that says Congress has necessary and proper power to decide which components of the executive power are insubstantial enough that they can take it away from the president.
Can I just quickly follow up on that?
Sure.
Which is, and it goes back to something I left from what you said in your opening remark. There is a perception, which I used to hold, when I read Humphrey's when I read Myers as a law student, I thought this is wrong as a matter of history. And when I read Humphrey's as a law student, I thought they're just making this up. And as it turns out, other historians, and I've dug into this too, the language of quasi-legislative and quasi-judicial was not invented in the 20th century. It is language that goes back to the 19th century, and there's a through line that I'm not going to get into, but for another article or another project that Yolanda and I were debating yesterday, the separation of powers is much more complicated than people assume. From the formal separation of powers is a late 20th century creation, more or less. The founders were still working out in inchoate versions of legislative power, executive power, and there's no separation of, there was, the 6 states in the original state constitutions had separation of powers clauses. The framers didn't adopt one, and there's good reason why. Their model was more checks and balances of overlapping powers, like the decision not to give the president full appointment power, but to divide that traditional executive power with the Senate. It turns out that model of informal separation and checks and balances was the framing, and there's a through line from that to Humphrey's of this sort of overlapping quasi-legislative, quasi-judicial.
I agree with 40% of that.
Thanks. So,
I think I'll take it.
So we have time for me to ask one more sort of laden question, and then we'll give a generous amount of time for Q&A to the audience. This one goes back to Marbury. You mentioned, Ilan, and you're like anyone who teaches Marbury, it's a super precedent, but there's also all kinds of untruths in the opinion. Like the most obvious one to me actually is its maximum ubius ibi remedium, right? So for every violation there is a remedy, and that's just like totally not true. There's all kinds of things that go wrong that courts cannot resolve for you. But this brings me to page 20 of Solicitor General Sauer's brief, which is a stay motion which was granted on the 9th of last month, but also meant to be construed as a petition for cert, which is a court lacks the power to issue equitable relief restoring a removed executive officer. So one part of the debate that we haven't really sort of covered super well is what about that third branch, which there's like nothing in Article 3, Section 2 to work with here, just a couple words. And this sort of brings in some interesting themes of judicial supremacy versus departmentalism. Like, what's your take on the Article 3 power here?
This is great because I really wanted to be on a different panel today, actually, the injunctions panel.
Okay.
And so this is perfect.
Remedies is remedies is the most
now
under.
I'm hurt.
I feel like from a scholarly and a judicial development perspective, remedies is like it's the next big thing.
Yeah. So one point about Marbury, so I will answer it seriously in a second, and I'll do the equitable as well. Everyone understands that Marshall was wrong about basically everything, right, in that opinion. He was wrong that the commission didn't have to be delivered. He was wrong that the Section 13 of the Judiciary Act of 1789 gave original jurisdiction to the Supreme Court to issue writs of mandamus when it clearly says that when exercising appellate jurisdiction, it may issue a writ of mandamus. So he manufactured this statutory conflict, which actually may or may not conflict with Article 3. It probably does, so that's another reason. And he went through all these textual provisions for judicial review, which don't make any sense. I mean, he was, though, don't get me wrong, he was right on the bottom line, okay? So he's wrong about all of these things, and he's just right that President Jefferson couldn't remove William Marbury, like, from office for 5 years. I mean, it would be astounding if Marshall got everything wrong in that opinion but that point. Okay, so seriously though, on the merits of that question, there are a couple conceptions of the officer William Marbury. One is he was the Justice of the Peace for the District of Columbia, and some people have made the argument, including myself, that it's at least conceivable that he wasn't exercising executive power of the United States, but rather executive power of the District of Columbia, for the same reason that territorial judges did not have lifetime tenure. The theory seems to have been that they were exercising the judicial power of a different sovereign. I know Jed disagrees with me on this. I see him shaking his head out of the corner of my eye. But it is at least like a possible conception of why the removal power would not have applied. Another possibility is that they were actually Article III judges, and Congress messed this up by giving them 5-year terms. Some judges did rule that, make that ruling. It was disputed a few years afterward. And then there's just Marshall was wrong, and Jefferson did in fact fire all of the justices of the peace, and he reappointed some of them, right? So, you know, Marshall is not a saint. He's great, but he's not a saint, okay? And he didn't get quite everything right about that. On the judicial power generally, this is sort of a hobby horse of mine, so let me just say one thing about injunctions in particular. Everybody is talking about universal injunctions, which are a problem. Like, even if an injunction is owed or due at the end of the day, why does it have to be universal and apply to non-parties? Why does it have to be pre-enforcement? Those are all problems, but what people aren't talking about is when is an injunction even appropriate? And the answer is the remedy at law has to be inadequate. Okay, the Alien Enemies Act, well, I don't want to get too much into this, habeas is a legal remedy, right? And usually considered an adequate legal remedy. So an injunction would not be appropriate in that case. And you know, salary suits, Myers, Humphreys, okay, Humphreys was dead, so it was a bit different, like you can't reinstate a dead guy. But Humphreys, Myers, Perkins, which is an inferior officer case, the Wiener case, all of these were suits for salary. Mm-hmm. They were removed and they sued for their salary. Like, what are these judges doing? Like, issuing TROs, reinstating people? Sue for your salary in the Court of Claims and you will be made whole.
I've gone down plenty of rabbit holes here, so I'll just say one
This is a good bait for another one.
So I'll just say you can read the amicus brief that Aram helpfully cited. It's up on SSRN about the Marbury question. I will just say one sentence about that, which is if Jefferson, how do we know that there was consensus that Marshall was right? Jefferson wanted to remove and dropped the removal of the JPs, and no one argued when they showed up. Like the lawyers for the executive branch, no one even made the argument that they were removed. They argued on the terms that Marshall concluded, which was that they were removed. The last thing I'll say is a big picture point, which is to, again, this maybe is a statement in interest or against interest. There's a larger problem when it comes to judicial power as originalists. Judicial power at circa 1787 was much narrower. Judicial review was a thing, but judicial supremacy was not, and the use of, nationwide injunctions, I mean, as much as I'm sympathetic to them now, I think to follow, agreeing with Elon as a big picture point, I think both sides have to acknowledge that judges are using have inflated, escalated judicial power far beyond anything that was conceived of in the founding.
Well, thanks so much. Now's a good time to introduce Q&A, and just for the record, I do agree with the holding of Marbury versus Madison, and a lot of the reasoning. Just to say that.
I agree with the holding, not the reasoning.
Yeah. You, sir.
Sir. Ramon Buehler with the Madison Coalition. My question is, if the Supreme Court should overturn Humphrey, would each of you favor a constitutional amendment which would give Congress the authority to authorize certain officers to serve for a term who couldn't be removed at will by the president? Some kind of amendment to restore the authority that Humphreys now gives.
Yes, and I'd also leave the necessary and proper clause, or either elaborate. I would say yes, and the necessary proper clause would still be in the background in case it was hard to work out the details of that amendment. I like shorter amendments than longer because they're more likely to pass. So the necessary and proper clause is the 18th century backdrop that would set contours on how robust that right was, how robust that power was.
And of course, I've already committed myself to the position that the original understanding, as I understand it, is a brilliant distribution of political costs and structures this quite well. And so I think I would stick with that, right? I think at the end of the day, who decides if the president did or did not have the proper cause, right? So suppose we reinstated that authority and then what? Made it judicially enforceable? So a court's gonna say, no, you didn't actually have cause, and the president said, no, I really did have cause. How dare you think you know more than I do about the execution of the laws by this officer for whom I am responsible? What's that gonna look like? I mean, it's just, it's we the people at the end of the day are the check on the president's removals here. As Madison said, and he did say this, so in the debates in 1789, the wanton removal of meritorious officers will subject the president himself to removal from office via impeachment. And I think that's right. I think that's right.
Sir?
So looking at James Madison argued that effectively the modern Secretary of State was removable at will by the president, and that the legislature could not limit his authority to be removed. But at the same time, as Professor Sugarman had talked about, the comptroller, he said, should be limited at terms. And I think resolving that disagreement, in my mind, I posit that the comptroller did not have any executive power. If you resolve it like that, you can keep Humphrey's executor while not conflicting with the vesting clause and the take care clause. And I would also potentially posit that the monetary functions of the Federal Reserve could potentially be protected from removable as not exercising executive power, although the modern Fed with its regulatory approval over banks would not. What do you think about that possibility of kind of resolving the disagreement consistent with Madison's views?
I think it is very important to disentangle different ideas here. There are some powers, okay, that it is true must exclusively be exercised by one branch or another. Maybe prosecution, the people debate about that. Conducting war has to be done by the executive. Whatever your vision of the non-delegation doctrine is, the creation of intelligible principles, that has to be done by Congress. Divesting someone of private rights, vested private rights, has to be done by the courts. There is, however, a lot of functions the government can do that is amenable to be exercised by more than one branch exercising more than one power, okay? So could claims against the government that the comptroller resolved be assigned to the courts? Of course it could, because it is amenable to an exercise of the judicial power. There would be a case or controversy, it would be contested, and so on. This is a public right. This goes back to Murray's lessee. It could be assigned to the courts. Could it be assigned to the Court of Claims, an executive branch court? People call it an Article I court, whatever that means. It's an executive branch. Of course it could, right? Because of sovereign immunity, doesn't have to consent to be sued. Could it resolve, which is what the comptroller was, instead of the Court of Claims, it was the comptroller. Could Congress resolve by committee claims against the government and then pass private bills? Of course it could, because it's a public right. But when Congress acts, it must act with bicameralism and presentment. When the courts act, they must act with lifetime tenure judges, right? And when the president acts, or when the executive branch acts, it must comport with the strictures of Article II, which I have hypothesized or tried to establish requires that control by the president. So the fact that it could be exercised by more than one branch doesn't change the relationship of the president to the officer if that task is assigned to the executive. That's my view of it.
Thank you.
Can I just very, I'm going to answer more with a syllabus or a reading list. But so this argument is something that was most developed by Jerry Mashaw and Cass Sunstein and Larry Lessig back in the 1990s articles. Mashaw's book comes out in 2008-ish, where the upshot is the three powers were identified as functions of the power of the purse, Article I, the power of the sword, Article II, and the power of the word, persuasion, Hamilton, Federalist 78, a power to persuade, not necessarily the president, right? So to piggyback on what you're asking, right, there was an original understanding that there was an in-between, with the informal checks and balances, informal separation of powers, the power of the purse was more in the shared domain of Congress and the executive branch. That helps explain the sinking fund. That helps explain Madison's comptroller. And an outstanding book is by John Brewer, not Justice David Brewer. John Brewer writes a book called Sinews of Power. I rely on it heavily in my article, Venality. the English tradition was to give treasury. The way that England became a global empire was the most powerful navy. How did they build the most powerful navy? The most powerful treasury. How did that treasury become so powerful? By giving its officers life tenure. Life tenure for treasury was the story of the English empire in the 17th and 18th century, and that's very much the background original public meaning of what the Americans inherited or understood about unremovable offices as property from the story of venality.
Thank you. So just for the remaining questions, if we could try to have sort of like quick responses.
Sorry.
No, it's
And
just, this is good.
For me, that was quick.
We have the time
Sorry,
constraints.
yeah.
Sir? Yeah.
Stephen Taft, thank you, sirs. I want to divert the discussion briefly to inferior officers, because something you mentioned is quite relevant, perhaps, about how the notion of a lifetime appointment or even holding one's office as a kind of property right you implied was contrary to the Republican spirit of the founding and more reminiscent of the Westminster system, perhaps, or even despotism. So what implications does this have for procedural due process and the supposed shielding of civil servants from removal?
I'm going to yield you all my time.
So no, for this one, I think we need to go a little longer, and I construe this as inferior and non-officers as well.
Okay. Excellent question. Everything that I had said was really about principal officers. And why do I say what I say about principal officers? Because I take the opinions clause seriously and the challenge that it poses to sort of the conventional view. I believe there can be these sort of spheres of independence that these principal officers have, subject always to the president's supervision through removal. So that's for principal officers. For inferior officers, my read of the text and the history is the inverse, or is it the converse or contrapos? I don't know exactly my logic here, but I think it's the inverse, which is Congress, at least this is what the history has just sort of established, can probably create for-cause removal protections, okay, for inferior officers because they have to follow orders anyway. That's what it means to be inferior. So in the Perkins case, which is one that established this, you couldn't discharge during times of peace a naval cadet in that case without a court-martial. No one doubts that the president had the power to direct and command the cadet. So it's really not sort of an issue. ALJs who have for-cause removal protections, every single decision they make is subject to be countermanded and reversed or removed or modified by the agency head who is politically accountable. And so executive power in that sense, right, stays intact. Is there some degree of creating property interests in these inferior officers as a result? Yes, and that makes me uncomfortable. It makes me less uncomfortable than principal officers who have this greater discretion and this sphere of independence in a way, because again, they can exercise duties given to them by Congress, and the president doesn't have that right of control. So it does bother me. History could have gone a different way. So the reason, the constitutional theory as to why they have removal restrictions is because by granting the appointment of the inferior officers in the head of department, which the Constitution allows, right, the removal power comes with it. I agree with that. That's obviously true. So you can insulate inferior officers from the president by interposing the decision of the principal, the head of the department, right? If removal comes with appointment and Congress can vest the appointment of the inferior officer in the head of the department, the removal power comes with that. Does it follow, which is what the courts have held, that therefore Congress can also restrict the ability of the head of the department to remove by creating for-cause restrictions? I don't know. I don't know. If I had been there in 1886 or whenever Perkins was decided, I would have probably said you can't do that. I would have said you could interpose between the inferior and the president, the principal, the head of the department. That doesn't mean you can have for-cause protections. But I also don't lose that much sleep over it because inferior officers by definition have to follow orders. And so in this case, what do they say? A page of history is worth a volume of logic. The logic bothers me, but the history, much more clearly resolves it in favor of restrictions on inferior officer removals. Did it have to go that way? Is that the best answer? I don't know, but I'm also not going to lose sleep over it. I don't think. Maybe tonight I will because of the question.
My one sentence is that I appreciate Elon has been more open-minded about the debates, the historical and textual debates, than other unitary executive theorists. And I just want to commend Elon We learn from each other. We are accountable. There is a degree of we're independent, also accountable to each other, and I think that's the way scholarship is supposed to go. And so I'll just say, I'm happy to debate any unitary executive theorist anywhere, anytime, as long as I can check with my wife and her schedule.
Thank you. Ma'am?
For me, it's anywhere, anytime.
But you've got, Ilana's expecting a baby in the next month, so that's, I can say.
I stick by it.
I just really enjoyed the program today. I work in finance, so I want to go back to this issue of trying to single out the Fed. There was a well-known interchange with one of the former Fed governors where, after acknowledging the pressure that could be brought to bear on them and really the control either by Treasury or Congress, his answer was, yes, but if they did that, who would they have to blame? And to my mind, what really singles out the Fed is simply there is so much vested political interest in creating the appearance of independence. And I completely agree with the statement where you said, look, nobody's independent. Obviously, the courts aren't independent in politicized cases. So I wonder, I gathered making a special case for the Fed, Ilan, you would say no. And Jed, I'm more interested in hearing a little more of a basis as to why you think that would be upheld.
Let me just see if I could, because the emphasis on the importance of accountability as the balance there, right? So I think that's the kind of the arrangement under a loose, necessary, and proper arrangement of the balance here. I mean, this, Ilan knows that there's a chapter in my forthcoming book that I just can't include in that book, but that the history of independent agencies is not as independent as you would have thought. So the Interstate Commerce Commission, I'm gonna avoid going down all the rabbit holes, but the Interstate Commerce Commission is the granddaddy of independent agencies. It was not, no one called it independent at the time because there was a balance of these interests. What I will say is we have reached that compromise by not saying the Senate has to agree to any removal. That might have been an 18th century solution. The settlement that we have over the course of the late 19th century through the 21st century is having to show inefficiency, neglect of duty, or malfeasance. Those are permissions, not just protections. And I have a more capacious view of what constitutes good cause, right? So if Congress has chosen good cause, that gives a lot of latitude for a president to make a policy argument for removal. And depending upon how capacious one wants to interpret inefficiency, neglect of duty, or malfeasance, that gives the president a lot more latitude than you might have imagined for being able to make those choices of accountability. So I think and because the president retains that choice, the buck does sort of stop. Or in the case of tariffs, the buck might be crashing at the desk of the president.
Thanks so much, Jed. Thanks, Ilan. And we will find out in the next year whether there is really the end of Humphrey's Executor. Our next event is at 10:35. Thank you.
Oh, wow.